trial court here has awarded a death sentence to former techie Nino Matthew for the gruesome murders of 3-year-old Swastika and 60-year-old Omana or Vijayamma of Alamkot near Artingal. The second accused in the case, Anu Shanti, who happened to be the mother and daughter-in-law respectively of the deceased, was awarded life sentence for conspiracy of murder. Nino Matthew gets 5 years rigorous imprisonment and rupees 1 lakh penalty for criminal trespass, life sentence and rupees 1 lakh for criminal conspiracy, 1 year and rupees 50,000 for destruction of evidence, 3 years and rupees 1 lakh for theft, capital punishment and rupees 50 lakhs for murder, 10 years and rupees 5 lakh for attempt to murder, and 4 years imprisonment and 1 lakh rupees fine for transmitting obscene content in digital form. Anu Shanti, who was also found guilty of the same charges, was awarded same sentence except for the charge of murder, as she was not directly involved in the crime. She was therefore awarded life sentence. Reading out the order, Principal Sessions Judge V. Shersey held that the crimes committed by the two accused were heinous and beyond any comparison. They conspired together and carried out the crimes in order to gratify their lust. Describing Nino Matthews' actions, the judge held that the crime was committed in the most brutal way. One of his victims, Swastika, was younger than his own daughter, in fact. Omana, too, was a hapless victim who had 14 cuts on her body. Her brain was also smashed after being bludgeoned by a baseball bat. About Anu Shanti, the judge held that she was ashamed to motherhood. However, she was saved from extreme punishment as she was a woman and represented the weaker section. The judge also held that from the total amount compounded as penalty, rupees 50 lakh would go to Anu Shanti's husband and Swastika's father, Lijesh, and rupees 30 lakhs would go to his father and Omana's husband, Tangapan Chettiar. The case pertained to the murder of Swastika and Omana and an attempt to murder on Lijesh at their house at Alamkot on April 16, 2014. Uh, this basically represents the prosecution case. Um, and it was that the two accused who shared an extramarital affair had a plan to terminate the family members of Lijesh so that they could live together. Now, moving on to the facts, the on-ground facts. Nino Matthew was arrested for allegedly murdering Swastika and Omana. The police said that, as was mentioned before, the extramarital affair that bloomed between the two IT professionals resulted in the well-planned murder. Nino Matthew came to Anu Shanti's house at Artingal at 12:30 p.m. On a Wednesday, on the pretext of inviting him for a marriage. He told her mother, Omana, that he was a friend of Anu Shanti's husband, Lijesh. He asked her to call back Lijesh, who had gone for some work nearby. After the mother called him over phone, Nino Matthew stabbed Anu Shanti's daughter, Swastika and Omana. When Lijesh returned home, Nino Matthew attacked Lijesh as well, but he escaped with injuries. It was Lijesh who informed the police that Nino Matthew had attacked him. Anu Shanti was at office at the time of murder. The police says that Nino wanted to eliminate all members of the family to lead a life with Anu Shanti. And they also say that Anu Shanti was aware of his intentions and aired the murder by sending him pictures of the house, the uh, particular rooms, and the escape route as well. The techies wanted to make the crime look like a murder committed for burglary. Nino took the ornaments worn by Swastika and Omana to confuse the police. But when Nino failed to kill Lijesh, the entire plan got derailed. These were the words of Artingal DSP R. Prathapan. Though Nino is a married person with a 4-year-old daughter, he was not in good terms with his wife, working in another company in Technopark. The relationship between Nino and his wife soured when the latter learned about his affair with Anu. The police also says that they were living in the same house but in different floors without communicating with each other. And now moving on to the theoretical aspect of this particular case, what is mitigation investigation for death row convicts? And what is the importance of the order by the Kerala High Court? The Kerala High Court has directed that a mitigation investigation should be conducted while considering the death sentence references of two convicts, Nino Matthew and Muhammad Amir. Uh, Mitigation investigation in death penalty cases involves the consideration of mitigating circumstances or factors that can encourage the judge to be more lenient with sentencing. Bench's Justices Alexander Thomas and C. Jayachandran directed the state authority concerned to file a report with relevant details of the two convicts, such as their age, family background, socioeconomic setting, criminal antecedents, employment history, and psychological history. Adding that this report would be referred to before confirming the accused capital punishment. The court made it clear that the reports shall be filed by the prosecution before the court in a sealed cover, which will not be perused by the judges till the issue of conviction is decided within the appeals. In its order dated May 11th, the Kerala High Court directed the Director General of Prisons to place on record reports from the jail authority concerning the convicts' conduct, nature of works done by them in the jail concerned. Additionally, the court appointed C.P. Shruti and Nuria Ansari, both associated with Project 39A of the NLU Delhi, to make an independent assessment regarding matters relevant to the case while asking them to submit a report before it, preferably within 2 months. For this, the court allowed them to visit the convicts in prison and conduct interviews. The court also clarified that Project 39A services will be pro bono or free of cost, and that their services have been frequently availed by the Apex Court considerably. The court also left it open for the state to conduct further investigations, and basically, that is what the High Court ordered. Directing the mitigation investigation to commence before it began hearing the convicts' appeals against the Sessions Court order. The court reasoned that there is no legal bar in the High Court at the appellate stage to commence mitigation study efforts even before the commencement of the hearing process on the issue of conviction. Reasoning that this would help in avoiding an unduly protracted hearing, the court also expressed concern that if mitigation efforts are undertaken only after conviction is over, there could be allegations of delay and possible deprivation of the convict's effective and meaningful opportunity of just hearing. And um, the amicus reports filed basically pertain to on December 15th last year. And the basic details are that Kerala High Court bench of Justices Alexander Thomas and Sophie Thomas appointed advocates Meeta Sudhindran and Sai Pooja as amicus curiae and sought their assistance in the mitigation investigation. The court's decision to seek the assistance of amicus curiae stemmed from a submission made by one of Nino Matthew's counsel, Advocate Sri Shastamangalan S. Ajit Kumar. During the hearing, Ajit Kumar submitted that in view of various later rulings of the Apex Court, the process of mitigation investigation may have been conducted by this court to assess and evaluate the aggravating circumstances and the mitigating circumstances for finally determining the issues in the death sentence reference or in etc. cases. After this, on December 22, 2022, the same bench passed another order where the amicus submissions were highlighted, stating that the matter of mitigation, investigation, and death sentencing process is a duly developed area, which is still in its infancy stage in India. informing that the Project 39A attached to the NLU Delhi, like I mentioned before, is a pioneering agency in the area of mitigation investigation, which deals with various aspects of death penalty laws. The amicus suggested availing the services of the said expert agency for effective conduct of mitigation investigation. In the entire holistic light of this, the court asked the amicus curiae to apprise it about the feasibility and the plausibility of investigating through Project 39A, at what stage the investigation would commence and be completed, and whether it would happen now or after hearing the appeal on its merits. On aspect of this particular case law that the court could use, directed the amicus to submit the same and to seek the assistance of the director of Project 39A on the practice of mitigation in various high courts. And also last year, while observing that a uniform approach is needed for granting real and meaningful opportunity to convicts on death row, and noting a clear conflict of opinions between some of its earlier decisions in such cases, the SC referred the matter to a 5-judge constitution bench. The uh, the comments of the SC on mitigation investigations are also important. In September 2022, a bench of then Chief Justice of India, U. Lalitha, and Justices S. Ravindra Bhatt and Sudhanshu Dhulia recalled earlier SC rulings on the issue of death sentences and said the common thread that runs through all these decisions is the express acknowledgement that meaningful, real, and effective hearing must be afforded to the accused with the opportunity to adduce material relevant for question of sentencing. What is conspicuously absent is consideration and contemplation about the time this may require. In cases where it was felt that real and effective hearing may not have been given on account of the same day sentencing, this court was satisfied that the flaw had been remedied at the appellate or review stage by affording the accused a chance to adduce material and thus fulfilling the mandate of Section 235, Clause 2. The bench, however, pointed out that in its 1980 ruling in Bachchan Singh versus State of Punjab, where it upheld the constitutional validity of the death penalty for murder while restricting it to the rarest of rare cases, it requires consideration and clarity, as the court had not addressed the question of what constitutes sufficient time at the trial court stage. Section 235, Clause 2 of the CRPC says that if the accused is convicted, the judge shall, unless he proceeds in accordance with the provisions of Section 360, which is order to release on probation of good conduct or after admonition, hear the accused on the question of sentence and then pass a sentence on him according to the law. In 2022, the Supreme Court in Mohammad Feroz versus the state of Madhya Pradesh reduced the death sentence awarded to a man for raping a 7-year-old girl to life imprisonment after taking on record the report of a mitigation investigator. And to wrap this all up, following this, the top court, the Supreme Court, registered the suo motu petition titled "In Reframing Guidelines Regarding Potential Mitigating Circumstances to be Considered While Imposing Death Sentences" to streamline the process of considering mitigating circumstances in such niche matters. However, the 5-judge bench verdict on this plea remains awaiting. So that is my analysis. Thank you.